Hello, everyone. My name is Steve Andrias, and I'm a public affairs specialist with the Copyright Office. Thank you all for joining us for today's first session in our standard technical measures discussion. Today, we'll be talking about legal foundations, and I'm going to just handle a few housekeeping items before we start the show. So as an attendee, you are automatically muted for today. However, you can submit questions through the Q&A. That's typically you can see that at the bottom of your screen, the tab that will pop up. We have set a set time at the end of the session to answer questions, but we can't guarantee that we will answer everything that's submitted. And if you're having technical issues, please send us a question, or especially send me a question or a chat message, and I'll try to answer you and fix any problem you're having. And finally, this session is being recorded, and we are planning to post it on our website and YouTube channel when the recording is ready. And with that, I'd like to pass it off to today's moderator. Emily Lanza is with the Office of Policy and International Affairs. Emily, please take it away.
Great, thanks, Steve. Welcome everyone to the U.S. Copyright Office's kickoff discussion on standard technical measures, or STMs. As Steve mentioned, my name is Emily Lanza. I'm counsel with the Copyright Office's Office of Policy and National Affairs, and I'll be moderating the first panel today. As noted in the Copyright Office's report, Section 512 of Title 17, the Office believes that the identification of STMs provides an opportunity for cooperation and collaboration among creators, service providers, and users to use technology to improve the efficiency and effectiveness of 512 for all stakeholders. However, STMs, as with other areas within Section 512, are controversial, with disagreement about what measures currently qualify as STMs, despite the availability of various technologies and the potential interest in consensus building across industries. In order to build upon the report's recommendation to encourage and facilitate voluntary collaboration, the Office intends that the 3 panel discussions, including today's, tomorrow's, and next Tuesday's on the 29th, will lay the groundwork for a sustained engagement on STMs. With conversations among a diverse set of panelists, we will be exploring STMs, how best to develop and widely adopt such measures, and their potential as one flexible approach to address concerns about Section 512. With that, I would like to start panel number 1, Legal Foundation. With this panel, we hope to examine the nuances of Section 512I and its definition of standard technical measures. More specifically, our panelists will be discussing the current legal scope and accompanying obligations of an STM, and what obstacles, if any, the statute currently presents for identifying or adopting an STM. Before we kick off the discussion, I would like to introduce our distinguished panelists. More comprehensive bios are available on the STM discussion events page where you register for the event. So our first panelist is Anne-Marie Bridey. She is Copyright Counsel at Google. Our second panelist is Mary Rassenberger, who is the Executive Director of the Authors Guild and the Authors Guild Foundation. Our third panelist is Meredith Rose, who is Senior Policy Counsel at Public Knowledge. And our fourth panelist is Jeff Walker, who is Executive Vice President and Head of Business and Legal Affairs for Sony Music's Global Digital Business. Thank you all very much for participating in this panel. Each of the panelists will be giving a brief statement to lay the foundations for a discussion, and then I hope to begin our conversation in earnest with a few questions of my own before opening up for public Q&A. So with that, Anne-Marie, would you like to start?
Sure, thanks Emily and the Copyright Office for inviting Google to be part of the conversation today. When considering statutory reform, it makes sense to start from a close reading and a shared understanding of the statutory text. The DMCA sets 3 threshold requirements in the definition of standard technical measures. The first concerns the process through which a measure is developed. Under the statute, STMs can come into existence only through a voluntary process supported by a broad consensus of affected stakeholders. Voluntariness and broad consensus are the operative terms. The voluntary development of technical standards is usually accomplished through a recognized standard developing organization, SDO, according to a process agreed by all participants at the outset. Recognized SDOs include ANSI, W3C, NIST, and others. The Senate and House reports for the DMCA also contemplate that STMs could be developed through an ad hoc process, like the one that produced the Content Scrambling System, CSS, for DVDs. The requirement of broad participation and consensus in the development of standards militates against ex post designation of existing technical measures as STMs. Section 512I2A wisely prevents the government from picking winners among technology vendors and from dictating either the design of new online services or the redesign of existing ones. It contemplates development through a recognized STO or an ad hoc cross-industry initiative like the DVD Copy Control Association. Neither the statutory language nor the legislative history of the DMCA suggests that the standard development process should be initiated or overseen by the government. The second requirement in the statutory definition of STMs concerns licensing. Here, the statute borrows terminology from the field of standard essential patents, SEPs. The cross-reference seems to contemplate, though it doesn't explicitly require, that STMs will be patentable or otherwise protectable subject matter for which a license would be required. As with FRAND requirements for standard essential patents, Section 512I2B prevents holdup and other self-interested behavior by IP holders whose IP is incorporated into a standard that industry participants agree to adopt. The third requirement in the statutory definition is a burden-limiting one. It recognizes that cooperative rights management inevitably imposes some costs and burdens on service providers. That's fair, but Congress believed that imposition of substantial costs and burdens would not be fair. I'll note with respect to relative burdens that Section 512I refers to measures used by copyright owners, indicating that Congress did not intend to require service providers to make substantial investments in developing rights protection technology or incorporating it into their systems. The call on service providers to accommodate and not interfere is not a call on service providers to pioneer or develop. Moving from the text of the statute to its animating policies, it's important to recognize that the standard technical measures provision in Section 512I was created to be an affordance and not a mandate. It would be a mistake to assume that the current lack of statutory STMs corresponds to a lack of effective content protection tools for right holders. Standardization was bound to be elusive in a technological and cultural environment as dynamic and diverse as the application layer of the internet. The absence of STMs is an artifact of market diversity and service differentiation and not a policy failure. What proof is there that it's not a policy failure? The market has produced a wide range of accessible rights management tools for right holders of all types and sizes. Since 1998, a rich industry has grown up around online content and brand protection. The global content protection market is projected to be worth $6.9 billion by 2021. Google's own content protection tools for right holders are numerous. They include YouTube's Content ID and copyright match tools, bulk reporting programs for trusted notifiers on YouTube, Search, and Drive, an algorithmic demotion signal for pirate sites in search, a rolling cryptographic cipher to backstop YouTube's community guideline against downloading videos, and hash matching to prevent public sharing of previously claimed infringing files on Google Drive. In addition, standards to enhance rights protections online have developed outside the ambit of the DMCA and within the established SDO framework. An example is the encrypted media extension standard for web browsers, which was developed within the W3C and adopted in 2016 by all major browser distributors, including Google. EME provides an API that enables playback of encrypted audio and video from web applications in any browser, regardless of the underlying content protection system. Google works with right holders every day to help protect works on our services. When right holders come to us with problems, we try to find workable and scalable solutions. Accordingly, we don't see a compelling need for developing STMs at this time, and we don't believe a standard-based approach would be fruitful given the wide diversity of both content types and online services. Technical protection tools for online content have developed voluntarily and cooperatively over time. They are not standards in the technical sense of the term, but that detail shouldn't be cause for concern. Thanks.
Thanks, Anne-Marie. Mary, would you like to go next?
Thank you, Emily. Thanks for inviting me to participate in this important discussion today. STMs appear to be the most effective way to control online piracy on legitimate platforms. And we see that internet platforms that use STMs, such as fingerprinting, are able to keep most piracy off their sites. That is when they use them. And for instance, in the book world, Amazon uses fingerprinting, and we see little ebook piracy of entire books on Amazon. STMs have not developed as contemplated in the statute and have not been nearly as widely adopted as they should be or as Congress envisioned. And this is because Section 512, as interpreted by the courts, provides no incentive for their development, much less for OSPs to engage in standards processes to develop them. Moreover, the definition of STMs sets too high a bar of broad consensus by an entire industry. And it also assumes that copyright owners, not OSPs, implement them. It contemplates something more like DRM, not what we think of as STMs today. The drafters of Section 512 had really good foresight in understanding as far back as 1998, and we have to remind ourselves how early in the internet world that was. They understood that technical measures would be a solution to online piracy. But they didn't envision the way the technology would develop. So subsection I, 512I, is not perfect. And to accomplish what was intended, we believe it needs to be tweaked in a few ways. First, the statute needs to create incentives for OSPs to participate in standard setting processes and to adopt STMs, not just accommodate them. The language of the statute to accommodate and not interfere contemplates, as I said, DRM that's applied by the copyright owner and not STMs like fingerprinting that are implemented by the OSP with the copyright owner's cooperation. Second, rather than have STMs defined as the actual technical measures to be developed through a standard setting process, it should be the standards for STMs that are developed in a standard setting process. And I will explain that in a minute. So first, the incentives issue under the current interpretation of 512C and D to avail themselves of the safe harbor. OSPs need to comply with notice and takedown. They only need to comply with notice and takedown now, as well as register an agent. And of course, under I have some form of repeat infringer policy. So if an OSP is benefiting from piracy and the current system works for them, why would they engage in a standard setting process and agree to certain STMs? There's just no incentive there. Now, you could fix the knowledge standard so that OSPs with knowledge that its service is teeming with piracy would be required to take action to keep piracy generally off the site, but and that in turn would require adoption of STMs just as a practical matter, somewhat akin to Article 17 of the EU directive. But the knowledge standard is not the subject for today, and you could do this in subsection I. You could amend subsection I-1B, where it says that ISPs must accommodate and not interfere with STMs, and you could add a requirement that certain OSPs must implement STMs, must adopt them. For instance, OSPs that have received more than a certain number of takedown notices, say 10,000, I don't know what the number should be, in the last month or year, whatever the term is. And in other words, it's where the OSP has knowledge that its service is being used en masse for piracy. And that requirement could also be limited to OSPs with revenue over X amount. Like the Article 17 of the EU directive, I believe, sets that at 10 million euros of revenue per year. And copyright owners would be required to actively cooperate with OSPs to provide necessary files or other information. And I should note that this would only apply to OSPs that fall under C and D, not to pipeline OSPs. It wouldn't make sense there. So for instance, you could add something, you could add to I-1B something like, in the case of an OSP that has received more than X takedown notices in the last blank, that it implement reasonably available STMs, provided that the copyright owner provides it with the digital files and information necessary to do so. Then also in section I2, which is the definition of STMs, in the preamble, I would delete by the copyright owner, since again, it is the OSPs that use effective STMs today, such as fingerprinting. And instead of saying technical measures that are used by the copyright owners, or technical measures that are used, I would say standards for technical measures. The point here is that we do not need or even want the technologies themselves to be developed in a multi-standard setting process. But you could have a standard setting body, such as some of the ones that Anne-Marie noted, convene interested parties to develop standards or requirements for STMs. And this would be on a sector by sector basis. And that's because it makes no sense to have a committee comprised of the entire industry, copyright owners, and OSPs to develop a technology. The exact coding of an STM is going to differ from company to company as well as sector to sector. And the technology that exists now is proprietary. And to encourage development, you want to allow companies to own it and license it. It's much more manageable to have the standard setting bodies create standards. They would convene each sector separately, as I noticed, such as motion pictures, sound recordings, photos, books, other texts. And the standards would include requirements for the other part of the definition of STMs in I2, namely that they be available on reasonable, non-discriminatory terms. That's important because, as noted in our comments during the 512 study, the existing STMs are not usually available to creators and small copyright owners. So that's an important requirement, and also the requirement that they not impose substantial costs, which actually I would change that to be unreasonable. And of course, they have to be affected. And the standard setting body also could resolve any disputes between copyright owners and OSPs regarding the implementation of STMs. Alternatively, as we suggested in our comments during the 512 study, you could delete the whole notion of a standard setting process and revise the definition in I2 to say something like, technical measures that are commercially available, that have been adopted by others in the industry and shown to be effective. Thank you very much.
Good afternoon, everyone. My name is Jeff Walker, and I oversee the digital business affairs and content protection teams at Sony Music Entertainment. Sony Music is a global record company. You may be familiar with some of our record labels like Columbia Records, RCA Records, as well as our artists like Beyonce, Bruce Springsteen, or Travis Scott. As it relates to our discussion of Section 512I of the Copyright Act, and in particular its provisions concerning standard technical measures, I'd like to highlight here today two of Sony Music's strategic imperatives. First, it's vitally important to Sony Music and to its artists to achieve the broadest possible distribution of our music on fair business terms. Second, recognizing that our recordings have tremendous value, it is our duty to our artists to keep their music off of services that are unwilling to license. To do otherwise would give unlicensed services a competitive advantage over licensed services that respect and pay our artists. My role at Sony relates to both of these strategic priorities. The legal teams that report to me oversee the drafting and negotiation of Sony's license agreements with hundreds of digital partners all across the globe that make our music available through a host of varied business models. Recording artists today have come to expect ubiquity. They want their music to be available everywhere, simultaneously, at the push of a virtual button. It's our mission to realize the artist's vision and to achieve the broadest availability of our music by licensing in a fair marketplace, promising services and consumer models. As I expect we will discuss today, the establishment of standard technical measures that Congress contemplated in Section 512I is critical to these strategic imperatives. Indeed, without the broad adoption and accommodation of technology solutions by service providers, our job would be simply impossible. As it is, due to the size of our catalog, which contains well over 1 million recordings, our teams that support content protection have grown to include upwards of 90 employees and consultants working full time to simply identify and take action with respect to infringing copies of Sony Music recordings, including on UGC platforms. Practically speaking, finding, manually reviewing, sending takedowns for the hundreds of millions of uploads of our recordings on the unlicensed platforms is a Herculean task. But all hope is not lost. As I expect we will also discuss today, there are already a number of technological solutions that I see every day in the digital music marketplace that have already achieved practical consensus as standard, at least in as much as they are broadly in use among responsible services, easy for service providers to implement or accommodate, and adaptable to services of different sizes and types. Just by way of example, these include technologies that allow us to search a service and identify infringements on a large-scale basis, such as through web crawling or through access to an API provided by the service itself. They also might include automated content recognition technologies, ACR, like the audio fingerprinting solutions provided by such companies as Audible Magic and PEX, to name but a few. These technologies are increasingly used by responsible service providers, and when properly implemented, they are highly accurate, highly effective, affordable, and adaptable to services of all types and sizes. Whatever the definition of an STM may be, and whatever process may be required for the formal designation of an STM, these technological solutions, at least from my practical perspective in the digital music marketplace, have received broad adoption in the digital music marketplace and should already be considered standard technological measures under any common sense understanding of the term. Another critical point to make regarding these technologies is that it is not sufficient that they are simply turned on. It's not enough to simply implement ACR technology and then dial it down to the point where it does not serve the intended purpose. Any discussion of STMs must therefore also include the quality of the technology's implementation. To give you an example of how this works in practice, let me tell you about our experience with Vimeo, the popular video streaming platform. Vimeo has steadfastly refused to engage in licensing negotiations with Sony Music. They will not talk to us. Years ago, Vimeo implemented ACR through a reputable vendor. If implemented properly, the reputable ACR provider would identify and prevent unlicensed recorded music content, including Sony's, from being uploaded to the platform. To test their implementation of the technology, my team tried to upload a pristine full copy of a popular recording called Uptown Funk by Mark Ronson and Bruno Mars. If the ACR had been implemented properly, the file would not have been uploaded. That didn't happen. The file was uploaded without incident, despite its purported implementation of a bona fide ACR solution. To give you another example, Twitch, Amazon's popular live streaming platform, has also implemented ACR from a reputable vendor, but has chosen to implement it only with respect to a limited set of hosted content on the Twitch platform. They have yet to implement it in connection with so-called clips on the platform, and they don't implement it in connection with live streamed content. As a result, vast amounts of programming containing unlicensed copy of copyrighted music, including Sony's, are streamed through Twitch's platform every day, while Twitch sits back and claims immunity based on a distorted interpretation of the DMCA safe harbors. And this is our experience with a subsidiary of Amazon, a licensed partner of ours for its Amazon Music service. So you can only imagine the challenges we face in trying to get effective ACR implementation in place with parties who have no interest really in operating any kind of properly licensed service. I fully agree with the Copyright Office's conclusion that the balance Congress intended when it established Section 512 safe harbor system is askew. Decades of judicial misinterpretation of Section 512 have expanded the scope of the safe harbors far beyond what Congress intended at the time of the DMCA's passage. As a result, service providers lack meaningful incentives to come to the table to discuss and to formalize STMs, despite the availability of a broad array of technical solutions already in the marketplace. The Copyright Office has an essential role to play in bringing together all of the necessary stakeholders to achieve, in a formal way, the consensus on STMs that Congress expected would have been forged long ago. We're grateful to the Copyright Office for initiating this important dialogue and look forward to working with you and with our service provider colleagues toward the development of a fair and healthy ecosystem for all stakeholders? Thank you.
Yeah, so my name's, I am the Senior Policy Counsel at Public Knowledge. We are a consumer advocacy organization that focuses on consumer issues in technology and telecommunications. Ironically, my Verizon Fios goes out at about the same time every day, which is why I'm on audio only. So apologies, you all have to look at my headshot for this. So while I do not come at this with an industry-specific background, I can discuss what kinds of priorities and policy choices should animate a functional STM requirement system that does not stifle the free expression of the 229 million Americans who are in some capacity or another living their lives online, particularly right now in the middle of a pandemic. First, we have to acknowledge the sort of underlying issue, which is that the questions of identifying content and controlling access to it are two very different propositions. They have distinct effects and policy rationales, and any sort of reasonable approach to this question has to treat these two goals separately. Luckily, there's some support for this proposition in the statutory definition of 512 I2, which defines STMs as technical measures that are used by copyright owners to identify or protect copyrighted works. So again, identification and protecting those copyrighted works are two very different questions. If there's one thing that the documented failures of automated takedowns and algorithmic monitoring show us, it's that technical measures at the end of the day are very poor substitutes for human judgment when it comes to determining whether or not access to a work should be allowed. Now, what a technical measure can do competently to some extent, and not perfectly, but more competently, is identify the presence or absence of copyrighted content. Again, there are some limitations on this, and there's always going to be fundamental design questions, but it's much more solidly within the ambit of things we can solve with technical measures. And to harken back to Mary's opening comment in her statement about Amazon and whole book fingerprinting. This is a question that in some cases, while not solved, has been tackled more directly. What technical measures cannot do competently, really to any extent, is determine whether or not the presence of copyrighted content equates to grounds for removing access to it. Technical measures cannot make fair use determinations. They cannot tell whether a piece of content has been uploaded under an exception or limitation. It cannot tell whether that content has been previously licensed by the uploader outside of the platform's auspices. I testified about this at some length at a hearing on Section 512 in June at the Senate Judiciary IP Subcommittee. But it's worth repeating that copyright is not binary. The presence of copyrighted content does not equate to infringement, and technical measures are very poor substitutes for human judgment when it comes to determining the access or removal thereof. A couple other things I'll just keep brief that I would like to flag for discussion moving forward. One is that the reliability of any identification-oriented STM presupposes a lot, not least of which is a modernized and holistically complete registration record at the Copyright Office. The Copyright Office has made a lot of strides towards this, and hopefully we'll see even further progress in the coming years. But being able to reliably tie ownership information within an STM to match the ownership information on file at the Copyright Office is a big engineering question. The second is that to make STMs meaningfully available and to meet the statutory obligations in a way that does not create an anti-competitive bottleneck, any STMs should be made available under enforceable FRAND-style obligations for both rights holders and platforms. So, for those of you who don't follow patent side, I mean, the FRAND is fair, reasonable, and non-discriminatory licensing obligations. And the third issue that I wanted to flag is STMs are necessarily shaped in their priorities and interests, both philosophical and financial, of the stakeholders who design them. So I believe we should inherently be very wary of any STM developed primarily, let alone exclusively, by dominant commercial stakeholders, be they rights holders or platforms. And to extend that skepticism towards anything that is Thank you.
Great, thanks, Meredith. I think those statements just demonstrated that STMs are ripe for lots of discussion. So let's just dive right in, and I think we just start with the statute. So under section 512I2A, a measure can qualify as an STM if it has been developed pursuant to a broad consensus of copyright owners and service providers. But what is the meaning of broad consensus? And I think just to focus on those two words, what does broad mean? Does broad mean a particular sub-industry or a type of OSP or a type of content creator or all industries? And what does consensus mean? What is the level of agreement of stakeholders that would qualify as broad consensus for the statute for an STM to be adopted?
Hi, Mary, I give you some thoughts on that. Okay, thanks.
Everyone.
Thank you. So, I mean, I think broad consensus, as generally understood, means that a plurality of those at the table agree. It doesn't require unanimity, but it does require most to agree. And in this case, it would certainly mean that both OSPs and right holders would be among those agreeing to it, I think, just in the context. But I don't think multi-industry standards process necessarily means there's one process. I mean, that for all the copyright industries, that just wouldn't make any sense. I mean, it's just, there couldn't be such a technology. There are multiple copyright industries. I think, the book industry, we consider that an industry. The motion picture industry is an industry. So I do think that the statute actually contemplates multiple processes in each industry. It does use a singular for process, so it could be made clearer. But I think even without amendment, it's pretty clear that it means there could be any number of industry processes.
Thanks, Mary. Jeff, go ahead.
Sure. We agree with the Copyright Office that not every industry is required to achieve the broad consensus required under the statute, formally adopt an STM. We don't think the statute requires a one-size-fits-all solution. We see compelling evidence of broad consensus in the legitimate services that overwhelmingly permit or apply certain measures today, including those that I mentioned, the web crawling, API, and ACR technology. Some of these STMs may be more relevant to the digital music market, for example, as Mary was saying, than books or other copyright industries. But it's clear that within different segments of the copyright business, that there can be broad consensus that would allow us to adopt STMs across, for example, the music business. In our bilateral negotiations, because again, I'm coming at this from the perspective of someone who negotiates deals for a living, I'm not a policymaker, we see very little resistance to the adoption and implementation of technical measures by service providers that we license to, who we talk to on a regular basis. And despite the lack of formal adoption, which we take the evidence that, that consensus already exists.
Anne-Marie or Meredith, do you want to respond?
So yeah, I can imagine that a standard technical measure could be content specific and service type specific. So, as Mary and Jeff have already said, I think that different content types, match to different industries and have different corresponding service providers on the technology side. But at the same time, I think it would be counterproductive to create ambiguity around which services and which types of content are covered by which measures. So that would need to be sort of carefully thought through, given that fragmentation is really the opposite of what standardization is supposed to accomplish, right? So the idea of a standard is that it's going to apply across a range of stakeholders. But I think the key is that both the relevant content industries and the relevant OSPs need to agree on the standard, and that everyone potentially covered by this standard should play a role in its development, right? Obviously, unanimity is not required. I think probably something significantly more than plurality would be required, but I think the most important thing is that in the process of development, the stakeholders need to be all at the table.
Meredith, do you have anything to add for that?
Very little. I think it's, you know, sort of to echo what has been said, I think we, again, coming at this from a consumer perspective, very oriented towards competition policy, I think we need to have a process that reflects the fact that smaller platform providers and small artists on the other side do not have the same resources as I think a lot of the larger industrial interests in larger platforms, larger rights holders. They don't have the same sort of ability to, they don't have the same resources available to them. And so in order to make something that is meaningfully available both to small artists and to new startup platforms, I think we need to have a process that has voices from those communities involved. You know, obviously, well, everyone nowadays can be arguably a copyright holder, and so you can't get the entire world around one table to debate the development of an STM. I do think that there needs to be more than just, you know, one or two large stakeholders on either side to develop something like this and then claim somehow that it's representative.
So a lot of comments we received for the Section 512 report pointed to...
Having said that, I do acknowledge the tension sensing policy.
Yep. So that just leads right into my question. So, so a lot of the commenters in the Section 512 report pointed to that language specifically as a reason why no STMs have been formally adopted, and I know that's even a controversial statement in itself. So do you think that is the case now? Or are there other areas of the statute that have prevented formal adoption of STMs? If you agree with that statement, that phrase.
Well, but it does appear, I mean, obviously there has been no formal adoption. We do believe that in the market, there's evidence of a broad consensus, certainly in the music business, of certain technological measures that are just implemented broadly. But, you know, as the Copyright Office mentioned, and as I mentioned in my opening statement, judicial misconstruction of the DMCA has created an imbalance, and there is no meaningful incentive for the service providers to come to the table to really discuss and formalize STM. They have nothing to lose by sitting back and doing nothing. But they can rely on broad interpretations of the DMCA and continue to shift the burdens back to the copyright owner. You know, again, notwithstanding the lack of formal adoption, there are many de facto STMs today based on what we see in the market, including the examples that I provided. And ultimately, you know, we hope that the Copyright Office drawing attention to these issues, as well as Congress's call for action in the statute, will result in stakeholders coming to the table. And we, you know, we invite the service providers to have those conversations with us. We're absolutely open to it and welcome it.
Yeah, if I could second what Jeff said, and as I said in my opening comments, I completely agree. There aren't any incentives today for OSPs to participate in this kind of broad industry standards making process. So there has to be some incentive added to the statute, whether it's through heightening the knowledge standards and obligations, or in Section I itself by actually imposing an obligation on OSPs. And I do think the broad consensus of copyright owners and service providers is too high a bar when there's no incentives for half the party to come to the table. Also, as Jeff said, there already are a lot of very good, effective STMs out there and being used today. And so we need to find a way to bring those into the statute, and that could be either through the recommendation I made in my opening remarks, which is you develop standards that any technology, you know, might try to meet, and many existing technologies I would assume. Or you could revise it to say that it's more akin to how technological protection measures are defined in 1201. You know, they have to be commercially available, and effective. As I also said in my opening comments.
So I think that there actually are a lot of incentives and have been incentives to develop voluntary measures because we see them already in the marketplace. And so I think we're fixating a lot on whether these measures are taking the form of standards, and they're not, but that doesn't mean that the measures are not out there and available and being used on major platforms, including YouTube and Google's other platforms. And so, I think that there have been a lot of market incentives to develop non-standard voluntary measures, and I think we've seen those measures proliferating in the marketplace already, as both Jeff and Mary have acknowledged. I don't agree with Mary that we need to find a way to bring them into the statute. If they're already existing and they're already being used by content providers, I'm not sure why we need to sort of have a sort of statutory mandate for them. And then, let's see, what else did I want to say? I also wanted to say that there are also standard-based interventions that are happening at other layers of the internet technology stack, right? And so I mentioned earlier the example of encrypted media extensions for delivering streams of video content in browsers. And so the fact that nothing has happened within the scope of the DMCA doesn't mean that it isn't happening elsewhere, either in terms of standard setting in the formal technical way that we know it, or in terms of voluntary measures that are non-standard, but that are still delivering a significant amount of content protection for the benefit of right holders.
Can I just respond real quickly to something you said, Anne Marie? And that is, the reason to bring them into the statute, even though there have been STMs already developed, is one, they're not necessarily used by everyone. They're not necessarily used all the time. And that's why I want a requirement that they be used. And very importantly, as we talked about a lot in our comments, they're generally not available to individual creators and small creative businesses.
I would just add to what Mary's saying that, that what we see in the marketplace is that legitimate services do implement these measures, but illegitimate players that aren't looking sort of play nice in the market, don't implement them, and they have a competitive advantage, and the legitimate services are therefore at a disadvantage vis-a-vis the illegitimate players, which implementing it in the statute or making it a formal designation as an STM would address the.
I mean, it's hard to believe that the illegitimate players wouldn't have liability that would exist. I mean, I don't think the illegitimate players really are getting protection under the DMCA such that they would need or be able to rely on safe harbors. So I'm not sure how conditioning safe harbor on something would be meaningful for illegitimate players that aren't operating valid businesses to begin with, because it seems to me that they would then just have exposure for secondary liability or direct liability for infringement sort of outside of the ambit of the safe harbors.
My point is simply that they can complicate our efforts to manage our content and in the right cases, remove it from their platform by not implementing these measures.
I'd like to pivot to a different area of the statute. If we could talk a bit about the phrase under 512I2B, available to any persons on reasonable and non-discriminatory terms. Is this phrase intended to be a threshold requirement for the adoption of STMs? Or does it really carry an obligation once technology has been defined as an STM to continue to make it available on reasonable and non-discriminatory terms?
This is a phrase that comes from the world of standard essential patents, and I think that it's pretty clear that Congress intended to invoke that with the language about reasonable and non-discriminatory grounds. And so, the FRAND requirement that Meredith mentioned earlier and that I mentioned in my opening statement applies at the time the standard is adopted and thereafter, right, for anyone who needs to practice the standard essential patent in order to comply with the standard. But I would also mention, and I think this is contrary to what Mary said earlier, that in an ideal world, I think standards that would become binding in some way through public law should be free and open and not proprietary standards. So I think when we're thinking about standards development policy requirements for standards, that ideally those standards would be non-proprietary.
Yeah, just to clarify, Anne-Marie, that's a good point. I do not mean that the standards are proprietary, but the technology itself. The idea is that the standard setting body would create open standards available to everyone, standards or requirements for the technology.
But it is the technology that is the standard, right? So the technology is what is required to comply with the standard. So I guess I'm not seeing the distinction that you're making there.
Well, it would be requirements, you know, like requirements for software. There would be certain specifications that the STMs need to meet. And there's like any standard setting process. It's not usually, the standard setting processes don't usually develop technology itself. They develop standards.
Meredith,
But there's standards that need to be incorporated into technology. So I guess I'm not following. I guess I think Google's preference is generally to have standards and these kinds of things be, for if they're going to be required by public law for all players, that ideally they would be not proprietary at all.
Meredith, do users have a particular point of view with regards to the question of availability?
Yeah, I mean, we want them to be as broadly available as possible because obviously we want to encourage a competitive online ecosystem among platforms. And so the ability to make it a relatively smooth on-ramp for small platforms to comply with, for them to avail themselves of STMs that have been developed. The lack of enforceable sort of friend-style obligations creates a potential competitive bottleneck. And given the degree of concentration that we have seen in both the platform space and in sort of major content holders, that's an added concern that in the absence of sort of enforceable friend obligations, this could exacerbate that problem and really create a competition bottleneck. So I think users are best served by a competitive sort of online ecosystem, and a competitive online ecosystem in turn is best served by having broadly available friend-style obligations placed on any STMs that may be developed.
And I would agree with that, that it's for creators as well, having a competitive marketplace is very important.
I would just say that what I see from the business side in the market today is that the technical measures that we see being widely adopted are already available on reasonable and non-discriminatory terms. So just a handful of examples that I gave: web crawling, which allows for indexing and location of content; API, which allows for scalable search. They're created and made available by the services themselves. So it's really a non-issue as it relates to those sort of high-level constructs, whether they're available on reasonable and non-discriminatory terms. And then ACR, which is available, the larger companies like Google's build their own, right? But other companies that are available, once STMs can be formalized, we would anticipate that there would be an influx of entrants into the market to, increasing competition, which would likely make, the availability of these technologies, more secure and presumably at a lower cost.
Yeah, and I can envision even the larger companies that develop the STMs for their own use, there would be a market for licensing them. We see this in the book space. There are several different models. The Amazon's is proprietary. Apple has their proprietary technology. It's a little more like DRM. Adobe has a copy protection technology that anyone can license. I mean, there are an array of available technologies. And so some are open and some are not.
And so I guess the question is, if there's an array of available technologies already, what need is there to mandate them through the statute?
You want the OSPs actually using them. I mean, that's, as I said before, not all OSPs use them. And, I think like Google is an example where, yes, you do after, in some cases it's 40,000 notices you demote. But that's inconsistent. Anyway, I don't want to get into website blocking here, but there could, that's what I mean by standards. There could be a standard to say that, after 10,000 notices, after 5,000, I mean, depending on
Okay,
the
but
size.
that would be just a statutory mandate, but that's not a technical standard in the sort of standard setting sense of the term. And so I just think that the vision that you have really does depart pretty radically from the ethos of standards development, which is, I think, what 512I was trying to capture. So I just think that at a certain point, the notion of a standard kind of loses its connection to the standards development process as technologists understand that term.
I mean,
Well, I would disagree. I would just say because there are certain standards that existing technology already meets.
yeah, I just think the plain reading of the statute is that you should not be able to take advantage of the safe harbor if you haven't accommodated and don't interfere with the standards, STMs. And if they're not formally applied, then there are all these platforms that don't have to do anything.
Well, I think let's follow up on that issue, that language there in the statute, accommodate and not interfere with STM. So can we explore what does that really mean? What does that look like? What are the obligations the OSP must have to the rights holder and the user regarding STM technology? What are the obligations that the rights holder and user may have, if any, under the statute? So I'll open up to the floor there.
Well, I mean, I'll go ahead because I addressed this in my opening remarks. Is that it contemplates really something like DRM, which can be used by copyright owners, but it doesn't contemplate the types of STMs that are actually adopted by OSPs, because it says accommodate, not interfere with, as though it's simply about allowing copyright owners and their technology to subsist on their platform. So I think that could be a lot clearer. I think you could read it as accommodate to mean, implement, but I would love to see that be clearer.
So one thing that I just like to flag is that the way that STMs are described in the statute, so it's technical measures used by copyright owners to identify or protect copyrighted works. So we can be talking about something as simple as standardized metadata, which is a problem that obviously the music industry has been dealing with for quite some time, and specifically due to the complexity of the music production process. So I think a lot of what we're trying to grapple with here is the question of, what kinds of data are we going to attach? What kinds of data are we going to, if we have an STM that is recognized as such, to what extent do we need the platform to be able to recognize and process and parse that data rather than removing it? And, again, to pull from the context of patents and sort of the technical measures and standards on the patent side, typically when you're talking about standards, you're talking about a series of instructions and minimum requirements that any technology needs to be able to meet in order to meet the statutory definition or to enable interoperability, essentially. So this fundamentally, standards are a question of interoperability. And in this case, they happen to be interoperability between the content holders and the platforms in order to achieve what they want to do. The upshot of this is that frequently standards require certain kinds of technical achievements that fall under either that have been patented, they need certain kind of algorithms that may be subject to various kinds of intellectual property protection. And so when we talk about licensing obligations, we talk about FRAND, fair, reasonable, and non-discriminatory, there's language in the statute that specifically says, they have to be any standard technical measure that meets the requirements must be available to any person on reasonable and non-discriminatory terms. And so to the extent that these standards are going to incorporate certain kinds of things like fingerprint matching, which is fundamentally an algorithmic question. And algorithmic questions are almost always protected at best by trade secrets, at worst by patents, and are thus, susceptible to being not licensed. Fundamentally, it's a proprietary solution developed by Amazon. Amazon has the choice to not license it. In normal business conditions, that's fine, that's their prerogative. But the reality is we want standard measures that anybody can come and adopt under any terms. And so that is going to require some kind of licensing obligation put on them. So I think it's impossible, frankly, to talk about standard technical measures without having these discussions of how do we want to obligate the owners or the rights holders that control the underlying technology to which we are inevitably going to hold any platform that attempts to use these STMs. We're going to require that they have some kind of hash matching. We're going to require that they do some kind of fingerprinting. We're going to require that they do some kind of content identification of some kind. That is going to involve protected material, protected under various intellectual property regimes. And so I think it's, I think while I would love to see a system in which we don't have to grapple with the question of how much do we allow these things to remain proprietary and how much do we just say, oh, well, here's a standard and, do whatever you can to meet it. I think the reality is, from any number of standard setting processes on the technical side is that the threshold question, I think, in a lot of this needs to be, what kinds of obligations do we put on the companies which have developed the technologies that we are holding up as the gold standard and expecting other platforms to implement?
Okay, the language here, I think accommodate and not interfere with, right, conveys that STMs are intended, I think, to be relatively lightweight from a service provider's perspective, right? So it's not the service provider's burden to take the initiative in creating or designing STMs, right? The service provider is required to accommodate measures employed by right holders, right? Would include things like, as Meredith mentioned, keeping copyright management information intact, not circumventing TPMs, and again, the DMCA already provides significant independent protection for those two things under sections 1201 and 1202. And I think Meredith's emphasis on interoperability is an important one. And here, again, I think the encrypted media extension standard for web browsers is a good example, right? The EME, the idea is it will interoperate with whatever underlying DRM protection a streaming content distributor chooses to use, right? Or if we were talking about ebooks, it would be something that would interoperate with whatever, DRM for ebooks a publisher would choose to use. And as for users, we haven't really talked a lot about them, right? And what the OSP's obligations are to the right holder and users. And I think that any form of content protection, and this isn't only an obligation that flows from OSPs to users, I think it's an obligation that flows from both OSPs and right holders to users, would be that any form of content protection should respect the expressive rights of users, right? And that the law shouldn't encourage the adoption of any content protection technology that overblocks, and it certainly shouldn't become a standard.
I could just add, I would agree with a lot of Meredith said, and your last point, Anne Marie. It's so important for these standards to be available to everyone, including individual creators, which are users. When a user creates something and they want it protected, they should have the ability to have STMs applied to their work as well. As we all know, there's, in some cases, not that big a difference these days between users and creators. There are a lot of users that become creators.
I would just respond to that by saying I wholeheartedly agree with this. I would caution, though, that the difficulty in this is that a lot of works that are created sort of by prosumers, there are sort of various terms that have been used for the kind of, user side creators that exist on a lot of these major platforms. A lot of the work, and certainly not all of it, but it's pretty frequent in a lot of these contexts to see works which incorporate existing works. And you have problems of database integrity that come into play. And so one of the issues that we've seen where, for example, you have a pretty remarkable case that happened 2016, I believe. There was a clip on YouTube of a particular video game run through. There was a glitch in the game and somebody had recorded how you hit that glitch and then the sort of results of the glitch in the game. And that was not entered into the sort of, database of, copyright content ID. However, that clip was then used in 2016 in an episode of Family Guy. And that episode of Family Guy was entered into the database. And all of a sudden the clip from 2009 got a takedown because it had incorporated, or, this thing flagged it now as a binary issue. And so while I agree generally, I think, this is any sort of STM that we end up talking about as a reality really needs to be equally available, frankly, to creators large and small. At the same time, this is why I'm inherently skeptical of an STM which not only identifies content, but purports to immediately control access to it. Those access questions are much stickier. They're the contours of the law as it is designed assume a human eye in making these sorts of judgment calls about access issues. And so, there's a lot of questions about database integrity and who is going to monitor these kinds of things that I think we also, frankly, would need to grapple with in any kind of discussion along those axes.
If I may,
Go ahead, Jeff. I'll go after you. Go ahead.
I just wanted to say, I do think we have to separate out, as it relates to fair use inquiries or any other type of inquiries, sort of the establishment of an STM as an STM versus the implementation of that STM in any particular context on any particular platform. Because I think we agree when you're implementing an STM, fair use should be a consideration depending on the platform and the kinds of content that are available on that platform. Where when you're looking at the high level construct of what, technological measures should be adopted as STMs, it's, in our view, things like web crawling. That is conceptual. There's no reason to consider things like fair use in determining whether or not web crawling should be an STM, right? That's really the way I look.
Yeah, that's really a good point. And in fact, the implementation of STMs and whether fair use is considered or not, that is something that that a standard setting body, I could imagine a separate standard setting body be created for this, and they could manage disputes about implementation. But the point I wanted to address was something, Meredith, you raised in your opening comments too, and about the problem that automatic filtering can be overbroad and can take down things that are fair use. And you seem to suggest that manual filtering is better. I think, there's been at least one study that showed that actually manual filtering has far more mistakes than automatic. Two, I think you put really good brains to it, and you can actually manage to create a STM that is, or ways to apply it that accounts for fair use. We have some of the brightest minds in the world, creating these technologies. I think we can do it, and I've actually, to quote Amazon again, we've had good experiences with them when we've brought oddities to them. The other point I want to make is that no system is perfect. And I think that's really important to remember. There is no part of our law that is perfect. I learned this in law school. I'm sure we all did. It's like there's always some leakage. And I think we have to be comfortable with that. It's finding the right balance. You know, there will be mistakes made on both sides, but what we want ultimately is, you know, STMs that effectively take down most pirated content and don't take down most fair uses. And then when things are taken down wrongly, we want that fixed immediately. And that, I mean, that's another part of the law and the takedown statute that we've talked about in other forums, that putting back up needs to happen much more quickly. You know, the Authors Guild, you know, one of the tenets of our advocacy is free speech. So we are as equally concerned as the public knowledge is with not having speech, legal speech taken down. But as I said, I think there are ways to do this through automated technology. One of the things that we've all suggested is that you look for identical copies, you know, not with STMs, not partial copies, that maybe there are other solutions for partial copies. You know, I haven't really thought this through. I'll say though, you know, in the self-publishing world, we've seen there was a recent spate a year or two ago of copy and paste books, and the fingerprinting did not identify those initially. And those are obviously an issue too when you want to go after those. Those are books that were made through cutting and pasting from several different books. So they didn't have one complete book, but they copied from several. So, and there does have to be a way to address that as well. But I agree, there's fair use is an issue, and you know, has to be addressed. But that doesn't mean we throw out the baby with the bathwater and say, oh, you know, we can't use STMs because we might occasionally take down a fair use. Now look at the other side, get that fair use put right back up.
Anne-Marie, would you like to respond before we turn to, we have a few public questions, so would you like to respond?
I would definitely like to respond. And so it's true that, you know, some of the greatest minds at Google and some of the greatest minds in the world are at Google working on, you know, content ID. And these are sophisticated automated content recognition systems. But you know what? They're not magical. And filters aren't magical. And I think it's easy to say, well, obviously we want a filter that catches only bad infringements and, you know, and doesn't capture any fair uses. And the reality of the situation is that filters, even the most sophisticated filters that are operational now, cannot detect fair use. Fair use is context specific. And, you know, AI, as wonderful as it is now and as much as it's advancing, is still not really in a position to be able to understand the context in which speech is used and reused. And so I just would caution everybody about thinking that, you know, somehow technology is going to magically make sure that the rights of users are always protected. You know, it's an ongoing issue, and, you know, we invest a tremendous amount of resources in, you know, trying to protect fair uses of users. And, you know, there's a lot of human intelligence that operates in tandem with content ID to make sure the expressive rights of users are protected. And so again, I would just caution against the idea that we can just sort of magically specify that we will have technology that only punishes bad speech and lets all of the good speech through, because that's just not really the reality of where the technology is.
Can I just add, I mean, the stated purpose of an STM under the statute is to identify or protect copyrighted works, right? And it's not that the rights of users aren't an issue, but they're addressed in other ways in the notice of takedown process, so that if something is inadvertently taken down, a user can object. We would certainly review the file, and if it turns out that it is a fair use and it was erroneously taken down, which happens on occasion, despite us doing manual reviews of most files that we take down, it would go back up. I mean, it's really as simple as that.
So we have a few questions from our attendees, and attendees, please submit some more because we have some time. So the first two questions kind of address the topic of consensus, and I'm going to try to combine them both. The first one tries to get out, if everyone can't have a seat at the table and there's only a limited number who can participate, is that okay if they're representative of certain voices, and how would that work? And another part of that question addresses how do you make sure with broad consensus that STMs are available to independent users, such as independent musicians. Jeff, would you like to hit the music part first?
I'm sorry, Emily. I really didn't hear the first question.
Okay, so the first question was, is it essential that everyone has a seat at the table, or could there be a limited number of people at the table as long as interested parties have a voice that kind of represents their interests? And the second question is, currently some platforms only make tools unavailable to independent musicians and creators. Does broad consensus require the needs of independent users to be met? Not users, creators.
So I would, as someone who's not a policymaker, I don't know that I can really answer this question. I will say there are organizations that represent independent musicians, for example, like E2IM, who can hopefully collect the thoughts and comments of artists in the market. And I do believe that artists should be at the table, and small labels should be at the table in these conversations because they have an interest to be protected. How that happens, I leave that to the policymakers.
Does anyone else would like to give a stab at those questions?
Yeah, so I mean,
Sure.
there is precedent for this in that, this is how policy gets made all the time. Folks try to find representatives of all interests and have them discuss. Artists, especially small artists, obviously, I'm probably preaching to the choir here, are a very diverse and opinionated lot, and occasionally there's a lot of herding cats involved. Same thing with consumers; it's a difficult group sometimes to pin down in particular instances. We saw this with the Music Modernization Act in 2018, but I think there was an attempt there to structurally find ways to represent independent songwriters in that case, and to afford specific structural seats on boards, and some oversight of the process so that it wasn't strictly dominated by major music publishers, and you did have independent songwriters with a voice in the process. Obviously, not everybody's happy about that. There were a lot of critiques coming from the independent songwriter side as well. And so will we ever have a system which makes everybody happy? No, but I think there are certainly ways to attempt to accommodate the diversity of opinions. What I worry about is less, does absolutely everybody under the sun who has a copyright have a voice in this, and more, do we have a reasonably balanced set of representatives and stakeholders in this process so that we don't have a repeat of what frankly has been the situation with copyright policy over the last 30 years, which is you have very large concentrated interests on two sides of the equation, and the sort of refusal to acknowledge either small independent artists or consumers as a viable constituency. And so what I would hope would happen is that you have a situation where you can have these voices represented in some capacity, either directly or by proxy in the standard setting process.
Yeah, and I would add, I mean, look, there are a lot of standard setting bodies out there, and they do this all the time. They make sure that all of the interests are represented and at the table. It is a doable thing, and I think that's the first step to setting, developing any standards, is that you make sure that all interests are represented.
Great. So another question goes back to the phrase accommodate and not interfere with. So the question is, if accommodate and not interfere with merely means that the OSP does not strip out copyright management information or TPMs? How do we distinguish it from 1201? Was the proper interpretation of accommodate and not interfere with that it gives a different meaning than 1201?
So 1201 creates an independent cause of action. Like I think that these are separate parts of the statute intended to accomplish different things, right? So there's a cause of action for, intentional removal of copyright management information under 1202, right? There is a separate cause of action for circumvention of TPMs under section 1201. In section 512I, we're asking about, what should be a precondition for safe harbor for an online service provider. So 1201 and 1202 apply to everybody in the world and are separate from the safe harbors. And so, 1201 and 1202 could be actionable against individuals. They could be actionable against service providers, right? It's just the accommodate and not interfere with is obviously, in order to get safe harbor, you would have to accommodate and not interfere with, as a service provider, any of those measures that are regarded as standard technical measures, right? And so the conversation now is, we don't have them. Is that a problem, right? This is an exploration of the potential development of standard technical measures. I think 1201 and 1202 create separate causes of action.
Anyone else like to respond to that one? Okay, so we have several questions regarding Google's Content ID system. Anne-Marie, I think this is directed towards you. So would Google be open to licensing its technology, its proprietary technology, such as the Content ID system through licensing?
I think that is a question that is beyond the scope of this conversation, right? We're here to talk about section 512I and legal foundations for standard technical measures. Content ID is a proprietary technical measure that YouTube and Google have developed. It is not a standard technical measure, and so it's not subject to FRAND requirements. And so it's currently not a technology that we license. I mean, it's highly specific to YouTube. It's not an off-the-shelf product. It's not like a software program that you can buy. It's deeply integrated into YouTube's business model, YouTube's operations. It has a tremendous amount of technical operational support that it requires on an ongoing basis. It has a tremendous amount of human support for human reviews that is integrated into it. And so it really is not an off-the-shelf software package that would be easily licensable.
Yeah, and this is, to sort of piggyback on this, I think this is illustrative of the difficulties that come up when you just say, oh, well, stakeholders will develop their own. While I do acknowledge there's some need for flexibility given, the diversity of platforms and the diversity of kinds of content that we, presumably STMs would be used to monitor. At the end of the day, Content ID or something similar to, a generic Content ID, I guess, might be useful for some kinds of video-oriented sites, but they're not going to be useful at all for others. They're not necessarily going to be useful for Amazon. And so when you have private development of these kinds of systems, those developments are going to necessarily reflect the priorities and the needs and the business models of the groups that are developing them. Which is why, I think the statute, frankly, explicitly contemplates a working group that is not tied to any particular platform or content holder that could have a more holistic overview without necessarily being influenced by those kinds of very practical, business-driven concerns that have animated, existing sort of content monitoring models. And to step back, I wanted to pull back a little bit and touch on a question that the previous question that we were discussing, which is the question about interfering with STMs. One of the reasons that, we're very concerned about STMs, again, the duality of identifying content versus controlling access to it. At the end of the day, you do need a human being to make, these calls about certain kinds of access questions, whether it falls under a limitation or exception, whether there was frankly a hiccup in the algorithm, whether there is maybe a licensing dispute between two content holders that has started to play out, in getting via takedown notices issued towards users, who may have complied with what they thought were the licensing agreements, but ownership has changed, or there's a dispute between two rights holders. And we would like to insulate users from that, being stuck as sort of a middleman in those kinds of disputes. And so when you have language in the statute that, says that, a platform would not accommodate and does not interfere with standard technical measures, if you say that a standard technical measure must include the ability to automatically remove access to this content, then you are removing any kind of human review between flagging content as being copyrighted and it disappearing from the internet. Again, the problem that we suffer with in a lot of cases is that right now these algorithms are designed to equate those two things. That if it's online and it's identified and it's uploaded by anyone other than a very specific user who has been pre-approved either because of business relationships or whatever, that it is inherently infringing and needs to be taken down first. And those kinds of things create all sorts of problems with fair use, which, to beat the old drum, the Supreme Court has said that fair use is the necessary safety valve for the First Amendment when we're discussing copyright. You cannot have, First Amendment compliant copyright without some kind of fair use exception. And so if you have a system which equates, the flagging of material with its instant removal, you're going to have substantial free expression concerns. And so, I think it's much more reasonable from an overall policy perspective as well as a legal one to separate those two concerns and to focus primarily on identifying content and then, re-injecting some human evaluation back into the workflow before this content user speech is, basically disappeared from the internet.
Great.
Just want to add, can I just add one short point? Yeah, I just want to Meredith's first point that I think if you have incentives, if you improve the incentives for adopting STMs, then you for all platforms, not just the big ones that have already chosen for whatever reason to adopt some. You create a marketplace, necessarily create a marketplace for STMs that are open to everyone. In other words, the business will follow, and the needs to get to have consensus built STMs will as well.
Yeah, my concern with that is there's inherently a competition problem. If you're talking about STMs that have these ability, these sort of what are fundamentally, I don't think anyone can dispute, they're fundamentally technically complex things that we're asking them to do. We're asking audio fingerprinting, we're asking video fingerprinting. Depending on how far you want to extend it, we're asking for text or software fingerprinting in some cases. Those are difficult things to do, and the number of entities out there with the resources to do this, to develop these standards in the first place is relatively small. And they tend to be very well-established entities like Google or Amazon with access to large databases of content that they can use to sort of, run these algorithms and develop them on. And so I am deeply concerned about a world where we have standard technical measures, in scare quotes here, that are developed by a Google or an Amazon or a Facebook, and then deliberately held out or priced out of the reach of new entrants. And so you have a reconsolidation of market power in those large players. And that is obviously a little bit beyond the scope of the discussion that we're having right now, but I think it's irresponsible to have these kinds of conversations without acknowledging the extremely concentrated competitive landscape right now, or the lack of a competitive landscape, depending on how cynical you want to be, and not worrying whether or not certain methods of developing STMs are going to ease that or re-entrench that.
My experience is really inconsistent with what was just described. I mean, there are absolutely large players in the market that are creating their own technology, but there are also independent companies all over the world, not just in the US, who are developing technologies, audio recognition, print recognition technologies that are getting better and better, smarter and smarter every day. And frankly, it's the absence of the coalescence, the formal agreement around the STM that's sort of preventing us from getting more people to come into the market, since everyone would then be required to have them for fear of losing the safe harbor. So I feel like I just disagree with the characterization that was just made.
So I think I partly agree with Jeff here, right? And I'm going to disagree with Mary in terms of our needing statutory incentives for this market to come into existence. As Jeff said, there are already lots of different players out there developing tools for content protection. And the statistic that I cited in my opening comments, I think, is a pretty profound one, right? The global content protection market is projected to be worth $6.9 billion by 2021. I think there's a strong incentive for players to come into that market and get a share of that $6.9 billion. And so I think there are I think it's a very dynamic marketplace. I think it's growing. I think there is obviously a demand for these kinds of technical measures. The fact that they're not standard, I don't think, has been an obstacle to the development of a pretty healthy market here.
Well, unfortunately, we are at a time, and this kind of just shows that we have lots to discuss with STMs, and don't worry, there are more conversations to be had. So please join us for panels on Wednesday, September 23rd, Current Technologies and Their STM Potential, and Tuesday, September 29th, Standard Technical Measures Looking Forward. I would like to give a huge thanks to all our panelists for sharing their time and their expertise and their perspective on this fascinating topic that will surely have a big impact on all stakeholders of the Section 512 system. So with that, please join us for tomorrow's session. Thank you very much.
Thank you.
Thank you.